Okay, we're right at 1 o'clock. We'll go ahead and get started. Thank you so much for being here today with us. We will be sharing the essential estate planning strategies and hosted by Dean Dorton. Presenting today is Mark Camposano, Family Office Services Director, and Elizabeth Leatherman, Tax Director. This session qualifies for 1 hour of CPE credit. To participate, please scan the QR code on your screen and complete the short form. From there, you'll be able to engage and enter today's 3 required code numbers. We will call them code words, but they are really numbers. You must enter all 3 to receive credit. I'll also share the URL in the chat for your convenience. We'll be taking questions throughout the session, so feel free to use the QA feature at any time. And now it's my pleasure to introduce Mark Camposano and Elizabeth Leatherman.
Thanks, Kristen. As Kristen told you, my name is Elizabeth Leatherman, and I'm a tax director in Dean Dorton's Lexington office. I've been with the firm and in public accounting about almost 20 years now. Previous experience in a trust department at a bank. I'm joined by my fantastic colleague, Mark Camposano, and I'll let him tell you a little bit about himself while we kick off the presentation.
Great. Thanks, Elizabeth. As I said, my name is Mark Camposano, Family Office Services Director. I'm out of our Louisville office, and I joined Dean Dorton in April of 2022, but have been in the family office space for the past 25 years. It's a unique space, and it's a space that I really enjoy. We have great clients that we work with, and we're always dealing with unique opportunities. So having said that, I'd like to go ahead and get started with our agenda and objectives for what we're talking about today. So we're talking about the overall overview of estate planning. There again, this is essential, so we're not going to go into a lot of depth, into a lot of complexity. We want to talk a little bit about key documents to consider when you're doing your estate plan. We're going to give an overview of the federal estate and gift taxes. We're also going to have considerations for estate and inheritance taxes that are state specific. We're going to talk a little bit about common pitfalls, and that's more practical advice and lessons learned. And then we'll talk about best times and when it's appropriate to update estate plans.
Mark, I would just add there that neither you nor I is a practicing attorney, so we'll talk a lot today about some legal documents that are necessary for kind of this essential estate planning. But I'd like to mention at this point that the entire process is a team-based approach. So it will take your estate planning attorney, your CPA, potentially insurance advisors, etc., to get the whole package created. So we can explain what these things are generally, but we cannot actually prepare legal documents here at Dean Dorton. So what is estate planning? What are we talking about? Simply the process of arranging for the disposition and management of your assets after your death or your incapacity. Why is it important? Because some things that we're going to talk about today can help you avoid the probate process. Why would you want to avoid the probate process? Number one, it is public knowledge. So I can remember living in Cincinnati when some certain famous Cincinnati residents passed away, and everybody ran immediately to the probate filings to see what all assets they had. It's not generally something that most people would like to have made publicly available. So probate is, avoidance is one of our objectives in basic estate planning now. It's also incredibly expensive in some states, not necessarily in Kentucky, but I know that there are some states where the entire process can be long drawn out and costly, from just a court fees and how much you need an estate or probate attorney in that process. Also, avoiding probate is helpful when it comes to having access to assets quickly after someone passes away. And that can generally be addressed by asset titling, but we will talk about that as we go. Also, another objective for estate planning is to protect your assets once you're gone. I know I have had many colleagues in the past talk about that hand reaching out from the grave to control the assets, and that's not necessarily what we're talking about, but we are talking about that you want things and the wealth that you've worked for going to the people that you select for the purposes we select, or the charitable organizations you select. And this is kind of how you make sure that that gets accomplished. Also, for a lot of people in the country, estate planning is meant to avoid or minimize estate taxes. We'll talk about kind of what level of wealth is necessary before that's a consideration at some point today, and also to fulfill your charitable intent. One more item on probate is that at a minimum, assets that have to enter the probate process typically have to remain unchanged for about 6 months, and that's to let creditors come forth and make any claims against the estate. So, along with the privacy and the access to funds, like, it generally helps to avoid probate to the extent that you can. Oh, and with that, we have reached our first code word of the day, which I will leave up for just a few seconds to let you all go ahead and enter it in to the platform. Okay, moving on. What are the key estate planning documents? I'm going to talk about a few of these, and Mark's going to talk about a few of them. First of all is your will. This is a document that pretty much everybody needs in order to direct how your property gets distributed after, immediately after you're gone, or after the probate process wraps up. If you do not have one, the state in which you are living decides how your assets pass. And I can tell you in Kentucky, this is not always how you would think they would, especially in the case of a married couple. You would think, well, everything just goes to the surviving spouse. That's not the case, at least in Kentucky. The revocable living trust is another document that a lot of people like to add on in conjunction with their will. And this is the document that, if it's properly funded during your lifetime, you can still maintain access to the funds that are in the trust while you're alive. But because the trust governs where the assets will go, assets inside the trust can avoid probate. And then a durable power of attorney is something that most people prefer to have simply for someone to be able to handle your financial affairs if you become incapacitated. This allows your designated individual to kind of handle getting your bills paid or getting access to information so that they can assist if you're, for example, hospitalized and incapacitated, or deemed incapacitated for reasons like dementia or Alzheimer's and stuff like that. And so that is also what we consider part of your essential estate planning package. I would just caution here that for anything that we talk about today, where you are naming a certain person who will need to handle things for you, whether that be as a guardian for minor children, as a power of attorney, as your executor or executrix, that you just communicate that during life. It's not necessarily as important that people know kind of what dollar amounts they can expect when you're gone. That's never a pleasant conversation. But if they are going to have to do something, if you're asking something of that person, like, will you take my pet or my children, it's really good to go ahead and have that conversation while you're alive so that they can let you know if that's something they feel up for or not. Biggest surprise you can get is off the bat, somebody calls and says, oh, you've been named as the executor and you are now responsible for handling, the entire process of disposing of this distant relative's assets. That's never a fun surprise to receive unless it comes with a lot of money, perhaps. And then Mark's going to talk about some of the other more healthcare related items that we consider part of your essential estate planning package.
Great. So one of the other documents is the healthcare directive, advanced directive, living will. And this is an important document because it lays out medical decisions, especially if you're not able to act. As part of that, healthcare surrogate, you're appointing someone to act on your behalf when you're unable to do so. And part of the living will are the advanced directives of how you want to handle life prolonging treatments. So you make the decision. In some cases, you leave that up to the healthcare surrogate, but very important. And to Elizabeth's point a few minutes ago, communication is vital for someone to be in this role, for them to understand what your wishes are and how important that can be. One of the other documents is a HIPAA authorization. We've all gone to the hospital and the doctor's office, and one of the first forms you get is a HIPAA authorization, which you're giving the medical personnel the ability to talk to people there again on your behalf to understand information as it pertains to your medical situation. So it's filling that out and making sure that you have people on there that you're comfortable with them getting that information. One of the other documents we put on here was a DNR. It's not a document that a lot of people talk about, but DNR stands for Do Not Resuscitate. And why this is important is a lot of the hospitals that you go into, every hospital has their own form that they have specific to their hospital. And in a lot of cases, you have to fill that out because that'll dictate over your living will, what they can do. And if you have made certain decisions regarding your life prolonging treatments, this could interfere with that. So just want you to be aware of it. There again, if you're in a situation where you're being admitted or someone is being admitted, ask about a DNR form because it's an important document.
Mark, I heard recently from one of our mutual colleagues that the HIPAA authorization is something to think about if you have adult, and by that I mean age 18, children going off to college, that a lot of times, parents have encountered snags. So I don't have children, and therefore I do not know how seamlessly that kind of integrates into your whole, package of information you get from whatever school your child's going to go to. But it's something to think about. Are you authorized to discuss your child's medical history with treating physicians once they kind of leave home and are age 18?
That's a real important point. And in most colleges, at least from personal experiences, you fill out that form at the time. But there again, it's very important to have a copy of that form and make sure it's updated as well. So good point. So, and that brings us to our next point of topic, and it's regarding children. One of the questions I get a lot is, should I have a will? And one of my first questions is, well, do you have minor children? And if they say yes, I say definitely, because your will, you're able to identify guardians to care for your minor children if something happens to you. There again, to Elizabeth's point that she made earlier, it's important that you communicate this with individuals. If you have a spouse, you want to make sure that they're on board as well and that you agree on who that guardian is. and making sure that you talk to the guardian, because that is a big responsibility. There again, Elizabeth, you made the point that making sure that there are assets available to care for those children, because that's an expensive proposition, and you want to make sure that people understand what they have to work with in that situation. The other thing that's important is temporary guardianship documents. There again, that's to help if you're entrusted with someone else's child during an emergency, or if they're traveling without their parents. Perfect example is, if you're going down to Florida on spring break, and your son is bringing a friend, you want to make sure that you have one of these documents with you. And some of the common ones are a notarized child travel consent form signed by both parents, or a child medical consent form. There again, if something would happen and you have to go to the hospital, making sure that they can provide care without having to reach out to the parents can be monumental in certain situations. If you have a special needs child, there are specific trust terms, special needs trust, and there are attorneys that specialize with these trusts. The important things about the special needs trust is they're specifically designed to provide for financial support without disqualifying the child from government benefits such as Medicaid or SSI. So to Elizabeth's point earlier, you need a specialist in that arena to write those. And Elizabeth, you talked about this. If you have a child that's going off to college, making sure you have a HIPAA authorization form and healthcare proxy form there again, so that if they're not able to act on their behalf, that someone is able to communicate with medical personnel in their situation. The other thing to consider is if they're turning 18 or they're over 18, looking at considering having a basic will. And there again, that depends on what kind of assets they have in their name, but it's one of those things to consider as well.
Absolutely. Nobody really likes it when the government comes in and tells you what to do with your assets, or even the assets of your children. And it is now time for our second code word of the day. I'm going to give you extra time on this because we're about to get into numbers, talking about numbers and taxes. Okay, so now the fun stuff as the tax director on the call. The federal estate and gift tax. These are two separate taxes that are combined in a very certain way, meaning that every U.S. citizen has a dollar amount that they can give away without reporting or without paying transfer taxes, either during their life or at their death. That number is currently 13.99 million per person, which is why I say that, the basic estate planning that we're talking about today applies to everyone. And the advanced estate planning is really for those people who, on a personal level, expect to have more than 14, 15 million, or as a couple, more than 30-ish million of taxable assets in their estate. And that just is, the value of your investment accounts and your checking account and your home and everything that you own. Starting in 2026, this number has been adjusted by the recent tax legislation to an even $15 million per individual, and that will be increased for inflation going forward. This is the quote unquote permanent fix. It's about the third permanent fix in my career, but this is the one that we were really waiting on, because the last time the exemption had a major overhaul was the Tax Cuts and Jobs Act in late 2017. And even after that, there was going to be a sunset at the end of this year. So all of us who are interested in estate planning and taxes or do that for a living were kind of nervously waiting to see what happened, because had it been allowed to sunset, the law would have reverted to pre-2017 numbers and potentially gone down to approximately $7 million a person, which personally still doesn't sound bad to me, given my level of assets, but our client base, however, might have been negatively impacted had that happened. But we're all good for now. But that quote unquote estate tax exemption of almost 14 and or 15 million next year is also the amount that you can give away tax-free during your life. So it's a use it during your life or use it at death or some combination thereof proposition. Also, in terms of things that you can, or amounts that you can give away tax-free, there is this gift tax annual exclusion, which is I, as an individual, can give up to $19,000 of value, cash or assets with a fair market value of up to $19,000 per recipient per year without eating into my lifetime exemption from gift and estate tax. So there's this annual amount that you can do. And then if you've exceeded the annual amount on a per beneficiary basis, then you get into the lifetime exemption. And once you've used up your lifetime exemption, then taxes start to apply or be incurred, meaning you're going to write checks. And those top rates for gift and estate tax is currently 40%. So, most people prefer to try to stay within, the limits and let the actual 40% happen potentially at death. Again, that's part of the discussion of a more advanced estate planning webinar that we have coming up. Portability is also an interesting development in the last several years. I say that because I can no longer remember what happened 5 years ago versus 25 years ago. It all feels the same to me. So portability means that between spouses, married couples primarily, you each have your, let's call it 15 million. Let's say that the husband passes away and doesn't have assets or doesn't need to use his entire $15 million. Well, the spouse, the surviving spouse, his wife in this example, could file an estate tax return and elect to have her husband's unused lifetime exemption transferred to her, so that essentially that $30 million remains intact for the family, the couple. This has turned out to be kind of a big benefit, because even when we expected the lifetime exemption to decrease or be cut roughly in half at the end of this year, anyone whose spouse had predeceased during the years that there was portability, that portability wasn't going to go down, and it still doesn't. It was just more meaningful when the current or surviving spouse was going to have a reduced exemption, as we thought, but that didn't happen. So right now, at more advanced estate planning to avoid payment of estate taxes isn't really necessary unless, as a couple, a married couple has more than 28 to 30 million of assets. So one more comment kind of on the $19,000 per recipient per year that is the gift tax annual exclusion. The only real exception to that the exception is for gifts to a 529 plan. So Congress gave U.S. citizens the ability to front load a 529 plan. For those of you who don't know what 529 plans are, they are kind of the tax preferential savings vehicle for college or for future education expenses. I guess we did just get them expanded a little bit for use beyond college for your kids, your grandkids, whatever. So I don't know how many of you are currently paying for college, but from what I understand, $19,000 doesn't go as far as it used to. And therefore, in order to kind of front load these, you are allowed to contribute 5 times the annual exclusion in any, in the first year or in at one time. It doesn't have to be in the first year of the 529. But let's say I form a 529 plan for my niece and I go ahead and put in $95,000 in the first year, which is 5 times the $19,000 annual exclusion. That means that I've already used up get my free $19,000 for the next 5 years as to my niece. So you might want to think about that. Like, what is the regular gifting program? Do you have a regular gifting program when kind of determining how much needs to go into a 529 plan if you plan to use this 5-year stretch? But also then, a married couple could put in together $190,000, per beneficiary plan. So that starts to be a little more meaningful when it comes to paying for college. The final thought on gifts, that $19,000 per recipient per year. The only other exception to that is if you pay educational or medical expenses for someone else and you pay those costs directly to the educational institution or directly to the healthcare provider, that is not considered a gift at all. And that you don't even get into the discussion of the $19,000 a year. So some people choose to just pay directly for their kids or grandkids to go to college, and that then is not considered a reportable gift. You would still then have the $19,000 for that beneficiary or that individual that you could give them in that year without eating into your lifetime exemption. So again, that is paid directly to the healthcare provider or the medical institution. You don't want to just give it to, your parent, child, whatever it is, and with the expectation that they will turn around and pay the institution. You need to pay it directly, or else it becomes a gift. And all of the other tax provisions come into play. On the state side, we really don't have state inherit or state estate. That's a lot to say together. State estate taxes in too many states any longer. A lot of states have really just done away with this since there is this rather large tax at the federal level once your assets get high enough, with the exception of Kentucky. And we do not have an estate tax, which is really a tax on the decedent based on the value of assets. But we do have what I like to refer to as the single and childless prejudicial tax of the Kentucky inheritance tax. And what this is a tax on the recipients of assets of Kentucky residents that only really kind of comes into play when you're passing assets to more remote descendants, like parents, children, grandchildren. These are all fine. Interestingly, daughters-in-law and sons-in-law are taxable beneficiaries. Nieces, nephews, in my case, taxable beneficiaries. And these Kentucky inheritance taxes kind of attach based on classes. So if you're class A, which is the immediate relatives, brothers, sisters, parents, children, grandchildren, those are class A beneficiaries and exempt from tax. And there are class B and class C beneficiaries. So for example, I mean, I do this for a living, and at some point, I'm not saying it was recently, but a few years into my career, I realized, oops, I didn't have kids, and I'm leaving everything to my niece and nephew because they are real and human and I love them. But if I do that, they are going to be subject to tax, and the tax rates go up to about 16% of the value of the assets. And so that just took a quick review, and rather than leaving things like my 401k plan or my IRA or my life insurance, to my niece and nephew directly, I'm going to have to leave it to their father, my brother, with the express instruction that, it's to be used for his children, because otherwise it's subject to tax. And I love my brother, but I don't think he needs my assets if something happens early. So those are the kinds of things we're talking about. That might be a little too much personal information for today, but those are the kinds of things that, become a surprise when, you're not prepared for the fact that Kentucky has an inheritance tax, and, it gets charged against whoever your assets go to. So it's not even, you can, again, I'm sure we'll address more strategies for, avoiding or minimizing that tax when we do our advanced estate planning webinar later this year. But be aware it's out there, and it probably also needs a quick review of where everything is going and what that's going to do, even on the state level. So your strategies, all this is to say that your strategies may be different depending on the state that you live in now or the state that you will be living in, when you pass away, if that's different than where you are today. And if you can predict that, good luck. We need to talk about some other things, because that, that indicates the level of crystal ball that I don't currently have. Also, where are your assets located? What banks, what financial institutions, in what states do you hold real estate, and what is the titling of those assets? Because like we said earlier, the titling of the assets, and we'll explain this in a little more detail in a minute, matters for probate purposes, for, are your wishes being effectuated through the way that you have your assets titled currently.
So some of the common pitfalls that we see are failing to update your estate plan after major life events. Change in marital status is a great example. If you change jobs, if I had my first job and, part of my benefits was a life insurance policy, and I named my brother because I wasn't married at the time. If I get married, going back, which kind of coincides with the next point, coordinating beneficiary designations with your estate plan. So now that I'm married, it's going back and making sure that I update that insurance policy to include my spouse, or going back to that 401k is a good one, where, a lot of companies, you have a 401k, you name a beneficiary, and then you just don't think about it. So making sure that you go back and do that. Holding too much life insurance in your own name. Life insurance in and of itself is a very efficient way to transfer assets, because life insurance, for the most part, is not taxable. So one of the pitfalls is if you name your estate as the beneficiary of your life insurance. So you've taken a very efficient product and you made it inefficient because you put it in your estate. By putting it in your estate, you've lost that tax efficiency. You've opened it up to the possibility of creditors because it's in your estate. If it's, being probated, then you open that up to creditors possibly getting after that. And then also the lack of liquidity, because now it's in your estate and it becomes, part of your probatable assets. As Elizabeth was just going through, not considering the state level taxes, depending on what state you live in. One of the big things is relying solely on a will without using a trust. One of the things that I learned early on was the importance of trust from a standpoint of, and I know this might sound silly, but if you look at death, death is the easiest thing to deal with from a standpoint of it's defined and what happens and you can go forward, based on, the documents that you have in place. What isn't so defined is the incapacitation. If somebody has a heart attack or a stroke and they're in a situation where they're incapacitated and they can't take care or manage their own affairs, and that could last for months, even years, and making sure that you have things in place in order for people to take care of those things while you're in that incapacitation phase. What we've learned about thus far is with wills is it doesn't address the incapacity. It can expose your assets to creditors. It can be costly and it could be time consuming. From a standpoint of a trust, you have the privacy aspect. It avoids probate and it allows for the ongoing managing of your affairs. So that's an important part. The last item we talk about is not coordinating your planning team when making estate plans. As we talked about earlier, it's important to have, the estate planning attorney, your tax accountant involved. And if you have life insurance, your insurance person, and your investment person, so you're not making decisions in a vacuum. You want to make sure that everybody knows and understands what you have. A couple of things too to talk about in this day and age. The digital footprints are important, and those are things that we need to talk about. A lot of the estate planning attorneys are including that in their documents that they're writing to make sure that we're addressing digital files because of the photos that you have and videos and documents and your online presence because of social media and being able to access your bank accounts, virtual property with cryptocurrency, things of that nature. I just saw a survey that was done earlier this year that said that the average person has 168 passwords. So if you're looking at passwords and logins to be able to manage those effectively, we really recommend the use of password managers. LastPass is one password. There's others that are out there, but giving someone the ability to access that information, and it makes it very easy to go in. You can keep notes in, identifying, keywords, things of that nature, and these password managers that really help out. And there again, if someone that you've named is taking over and managing your affairs, it's vital that they have that. One of the other things that we recommend is we have a client that we did this for some years ago, and we made a binder entitled it "Everything You Need to Know," and in that binder we had key information. On the first page, we put all the contacts, their emails, their phone numbers, and also the role they played with that client, so that the client had that information, or people that were acting on behalf of the client had that information. We included their copies of their documents, and a will and a trust, they could be 30, 40 pages. So we included a short summary that was 1 page, 2 pages max, that had all the key information in there. That was a good reference point for people that were looking at that information. We also included copies of the life insurance policies, or at least the first page that had detailed information, long-term care policies. We included a copy of the investment statement that identified the account numbers, so people could go back and look at that information. If the client had a donor advised fund at a community foundation, we included the fund document so that they knew what the terms were of that arrangement. We also included copies of real estate deeds in there so people understood how things were titled. And in some cases, we included passwords and logon information. Now, that's great to have that all in one place in this binder, but it doesn't help if you don't communicate that so people know where to find that binder, whether it's in a safe deposit box or if you have a safe, at your home. That's very important. So communication is key. One other thing that I encourage clients to do is to do a handwritten disposition of personal property. One is because it's private. Another is because it gives them the ability to change that periodically, where they can go back and change that information. If they have a new addition or a grandchild that enters the family and they want to leave something personal to that individual, and there are certain criteria, and your estate planning attorney can go through that to make sure that you do that correctly. But it's a good way that they can update as their family grows or as circumstances change without going back and having to redo their whole will at the time that happens. And I will say that what I've learned over time is, in a lot of cases, it's not so much about the monetary things. It's about those personal things, like your father's favorite watch or your mother's favorite brooch, that are so meaningful. And there again, that goes back to the communication aspect. It's great if it's your plan and you're able to communicate that to families so they understand that these are your wishes and this is what you want done. So Elizabeth, I don't know if there's anything else you want to add from the common pitfalls with your experience.
Just really that communication can prevent a lot of the common pitfalls or the kind of family disagreements or things that we encounter all the time in our practice. But I wanted to say further on life insurance, what we typically see is, at least in kind of what is no longer really the traditional family, but what used to be the traditional family, where you have one spouse who works, one spouse who stays home with the kids, is really not forgetting to put some term coverage, at least, on the spouse who stays home with the kids, because the loss, especially if there aren't significant, assets in the family otherwise, because the loss of that person is going to generate childcare costs, which can become astronomical if the working spouse continues to work and needs someone to step in and help care for the minor children. But to that end, it really serves as a kind of very, like Mark said, efficient vehicle for that person that I name to take custody of my animals when I pass. For example, we're always talking about Peaches, my dog, here in the office, and who will get Peaches. And it's not fair to leave Peaches to an individual to care for her in her custom manner of living without also leaving funds. And to the extent that I don't have the assets to leave, all of the money it will take, to take care of Peaches for the rest of her life, or substitute my children's names, whatever, for Peaches here. Life insurance is a very relatively inexpensive thing to stick in there and say, okay, whoever gets the kids also gets the proceeds from this life insurance policy. And that also, to Mark's point, gets the life insurance out of your estate. It's not necessarily in your name, it's tied to your life, but it's generally a tax-free receipt for whoever receives it, even if that's whoever you've named to watch your dog or your children, to be your children's guardian once you're gone. And those things are typically a temporary need, right? Like at the point at which the family has adequate assets to start worrying about potentially what we're going to cover in our advanced estate planning class, or has enough assets available to fund a bequest to whoever is going to be caring for minor children, pets, etc. Then that insurance is a little bit less important. But that's why I say it's relatively inexpensive, because I'm really talking term insurance at that point. You obviously can revisit this as children age and no longer require as much care. I'm not really sure what age that is, though. All right, we're to our third code word of the day. Okay, so that's a pretty good segue into when should you review your estate plan. Once it is created, any subsequent marriage, divorce, or with every marriage is what we're saying here, it is good to review what the estate plan says, make sure everything is as you wish it. There's nothing more embarrassing, again, than finding out that, your spouse's 401k at work is still listed as going to his first wife instead of you. And I've seen that happen at death once or twice, and it's awkward and horrible when it does. So it could have been avoided if he had just reviewed with every marriage, divorce, and remarriage his entire estate plan, including beneficiary designations. Anytime that you've got a birth or adoption of children, probably a good chance to review. I have recently assisted a client where 2 of the 3 grandchildren were alive at the time of the will being created. Client passed away. Client's executor realizes that, there's now a 3rd grandchild, and chaos ensues because inadvertently, through some unfortunate circumstances, that 3rd grandchild was left out. Now, I think it's going to be okay in their situation, but again, work that didn't need to happen. If you have a significant increase or decrease in your assets, in your wealth generally, like, again, it's not just the am I over 15 million or below, it is kind of at what point is this going to take some management when I pass, or as Mark so eloquently points out to us, or if I become incapacitated. Death is the easier option in those two. You become incapacitated and someone else is going to have to step in. It almost makes sense, if you're not kind of indigent, then all of us would need assistance, assuming, there wasn't a spouse there to kind of take over handling the day-to-day financial affairs in the event that I become incapacitated or anyone becomes incapacitated. Tax law changes. Now, this is the big one. Kind of everybody is aware that we had Tax Cuts and Jobs Act in 2017, or the recent OBBBA in July of this year. But the Secure Act and the Secure Act 2.0 happened in between and really, really dramatically potentially affected how IRAs and qualified plans can pass. So I recently had a client say, hey, didn't know if you were going to be in town, wanted you to kind of like look at what our estate plan is and let us know if it's time to contact the attorney to update it. And I was like, sure, I don't even think I have a copy of it and probably need that as well. as the person who kind of knows what your financial assets are because they do your taxes every year, look at the plan, immediately see it's drafted in 2011, immediately see there's an IRA payable to the estate, which might have been a better option in 2011 than it certainly is afterwards, after the Secure and Secure 2.0 Act. And all it took for me was the time it took to read through this binder of very well put together information and say, yeah, I think you do need to contact your attorney and let them walk you through, what's going to happen. Any questions on the tax side, feel free to give me a call. And that's very much appreciated from what I can tell, both on like the individual side as well as the attorney side, because in general, your attorney knows that that they bill by the hour, and they're probably not going to be calling you pandering to, do more work. You're going to need to do it as the client. So just keeping abreast when you hear on the news that there's been a change in the tax law, it might be worth an email to your estate planning attorney to say, is this something that I need? Absent then, if you're my client or a Dean Dorton tax client, you're welcome to email your tax partner, and we can kind of say, yes, it's time to contact your attorney, or maybe not, or let us look into it. When you move to a new state, so this is probate is a state specific exercise, and documents need to generally conform with the state. That can create, like we talked about earlier, some unexpected surprises if things are not reviewed. So don't think that just because you've set everything up and there's been no law change and you move from Kentucky to Florida, that there's not a reason to revisit your basic estate planning documents. It's still a good idea to check in with your estate planning attorney and find out what, if anything, might need to happen at that time. Retirement also, at the time that you retire, figuring out like what's going to happen. Will things be moving? Will the location of your assets and do your future plans change? And then traveling out of the country. We say this a little bit jokingly, but not really, because do you have that binder that Mark talks about pulled together? And honestly, I've yet to see an estate planning attorney who doesn't kind of also provide that binder. So that starts you off, and then you put all the other information in it. Do the applicable people know where to access that in the event that you're out of the country and need it, or they need it, something happens to you? I think the joke when we talked about this presentation previously was, I personally know that I am the executor for my parents, who are both living and healthy and all of that, thankfully. But every time they go on a trip out of the country, I used to get a frantic text from the airport, no doubt, saying, oh, our will is in this drawer in the kitchen, or whatever it was. And the investment statement should be in there too. And so at that point, I was kind of like, okay, that's great, but let's get to a point where we know where things are all the time, and you don't have to send me, you can just send me a, hey, we're leaving, love you, whatever it is, instead of kind of addressing your posthumous plans every time you get on an airplane.
So action steps going forward. So review of draft basic documents, will, power of attorney, etc. I will say that earlier in my career, I was actually a trust officer with JP Morgan Chase. And some of the worst conversations I ever had with clients were actually the surviving spouse when we went through the terms of the trust document. And inevitably the spouse would say, well, that's not the way it's supposed to be. And I'd say, well, that's what the document says. That's what we're bound by. So make sure that you really have a good understanding of the documents and what they mean. Be sure to ask the estate planning attorney to explain that to you so you have a clear understanding of that. Understand your net worth and potential estate tax exposure. So before going to your attorney, make sure that you put together your list of assets. Be sure to include cash values of life insurance and values of real estate, because these days there's a lot of tools that are at the disposal of the estate planning attorneys and the tax accountants, but a lot of it depends on net worth and what's applicable and what's not. So having a good understanding and being efficient with your time when you're meeting with the tax attorney helps. Begin making annual gifts if appropriate. If you're in that situation, as Elizabeth alluded to earlier, that can make a significant difference. We always think about gifting down naturally, right, to our children, but also in some cases it's gifting up, maybe to our parents if they're on a fixed income, and I'm in a position to help them, by gifting them, 19,000, or my spouse and I do, 38,000. That's very meaningful to somebody on a fixed income, where they're allowed to get that without, paying taxes on it. So remember that aspect as well. Discuss advanced planning with an estate attorney or tax advisor. There again, the importance of that communication. Consider having life insurance ownership and beneficiary coordination. And one of the things I'll mention is, give thought to their philanthropic goals. Life insurance is a great tool to use. If you want to make a legacy gift to an organization that's important to you or to your family, it's a good way to, create an endowed scholarship or things of that nature. So something to think about. Understanding how assets are currently titled. Elizabeth talked a little bit about that, but titling is important. One of the things to remember is, if you're in a situation and someone passes away, is making sure that you have assets that are available, cash, that's available to carry on. And especially if you're going through the probate process, to make sure that you have enough money to pay bills and things of that nature. And some of the things to consider are pay on death accounts, bank accounts where there's somebody else that's named on the account. So there again, it doesn't go through probate, happens automatically, and you have funds available. Cars, boats, things like that. My mother passed away recently in May, and when we purchased her last car, we put my name on the title along with hers. So there again, it gave me the ability to deal with that asset once that she passed. Looking at real estate, if you have a trust, looking to include that in as an asset of the trust, and that's very easily done with quick claim deeds. There again, talk to your attorney on those things. That kind of wraps up our formal part of the presentation today. I know we've hit a lot of topics, but there again, the good news is we have an advanced planning session that we're planning for October 23rd at 1:00. You can scan this QR code where it's easy to register, or there will be more information to go more in depth on more advanced topics of estate planning.
And in the 2 minutes we have left, if there are any questions in the chat, we'd be happy to take those.
It looks like we do not have any questions, Elizabeth.
Awesome. Don't forget to check out the app or the webpage